When your medical malpractice case goes all the way to trial, and now a jury is going to reach a verdict on your case, can the jury give you more money than what you and your attorney have asked for? Would you like to learn the answer? Come join me for a moment as I share with you exactly what the answer is. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, they can. The jury, if they find that the doctor was careless and that his carelessness was a cause of your injury, now they have to answer the series of questions about how much money you are to receive as full and fair compensation for all the different elements of damages you are claiming in your case. Now, at the very end of your case, when your attorney gives closing arguments, there are many times where an attorney for an injured patient will actually go ahead and suggest an amount of money that the jury should give to the injured patient for each and every element of damages. Now, for example, for a claim of pain and suffering from the time of the incident up until the time of trial, your attorney may suggest a particular number. And now, from the time of trial into the foreseeable future, for X number of years that the doctors have told the jury that you are going to suffer these ongoing injuries. Now, he may also suggest a number for the jury to consider. The interesting thing about a case going to the jury is that there is no set guideline of how much money the jury is required to give to an injured victim, to an injured patient. Instead, they are required to use their common sense, and collectively they are to come to an agreement about how much money you are ultimately to receive. So now, your attorney may suggest to the jury, listen, is $2 million sufficient to compensate this patient for all of the harms and losses they suffered and the pain and the suffering that they endured from the time of this incident up until the time of trial? And what about into the future? Is $10 million sufficient to go ahead and compensate this patient? And now they're going to use different analogies to show that injuries like this may be worth much, much more. And that's what's so fascinating about the whole jury system. Neither side knows what the outcome is going to be. And now when the jury's back there deliberating, trying to determine whether or not you are entitled to a verdict in your favor, and if so, how much money you are to receive, the question becomes, how much do we give this injured patient for all of her damages, for each individual line item of damages that she's claiming, for her economic losses, for her inability to work for the past few years, for her inability to work into the future, for her medical bills, for the suffering and the pain she can be expected to endure into the future for the rest of her life? Is $10 million sufficient? Is $15 million sufficient? Is $500,000 sufficient? It is all fact dependent. And it's also dependent upon your attorney. There are some instances where an attorney will not put a specific number on a request to the jury, but instead may use other examples of other people who have received money, whether it be a sports star or celebrities who earn millions and millions of dollars for making a movie or for playing a particular sport. And now they point to you as someone who's incapacitated, who's disabled. And they say, is it really worth $10 million for somebody to get this for a movie? But now this person is going to be sitting around for the rest of their life, unable to do anything. And so they're able to show and contrast what other people may have received, and now the jury is going to decide what you are supposed to receive. Can they give you more? The answer is, yes, they can. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I do understand and I recognize that you're watching this video because you likely have questions about your matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of bringing one, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.